Hi and welcome to SQE Success, your pathway to becoming an English solicitor. Today, we're diving into a core business law concept under FLK1. What's the difference between a limited company and a partnership under English law? This is a key topic for SQE1 and also essential if you ever plan to start a business, advise clients, or sit on a board. Let's break it down in plain English, with real-world examples. What is a limited company? A limited company is a legal entity separate from its owners. It's created by registering with Companies House under the Companies Act 2006. There are two main types: private limited company, most common for small businesses. Public limited company, can offer shares to the public. Key features: separate legal personality. Limited liability for shareholders. Managed by directors, owned by shareholders. Must file annual accounts and reports. See this example: Sarah and Tom set up a media production company called Creative Spark Ltd. The company signs contracts, owns equipment, and can sue or be sued. If the company fails, Sarah and Tom only lose what they invested, their personal assets are protected. What is a partnership? A partnership is formed when two or more people carry on a business in common with a view to profit. This is governed by the Partnership Act 1890, unless the partners have their own agreement. Key features: no separate legal personality, in general law, unless it's an LLP. Partners are personally liable for the debts of the firm. Profits and losses are shared. Less formal, no need to register with Companies House. See this example: Emily and James run a design studio as a traditional partnership. They don't incorporate, they just agree to work together and share profits. If the business gets sued or goes into debt, they are personally liable. Key differences: a limited company is a separate legal entity from its owners, meaning it can own property, enter contracts, and be sued in its own name. In contrast, a partnership generally has no separate legal personality unless it is set up as a limited liability partnership. In terms of liability, shareholders in a limited company are protected, they only risk losing the amount they invested, while partners in a general partnership face unlimited personal liability for business debts. Management of a company is handled by directors, whereas in a partnership, all partners manage the business unless otherwise agreed. Forming a limited company requires formal registration with Companies House under the Companies Act 2006, but a partnership can be formed informally, even without a written agreement, under the Partnership Act 1890. When it comes to taxation, a company pays corporation tax on its profits, whereas partners are taxed individually through income tax via self-assessment. Lastly, a limited company must submit annual accounts and other filings to the public register, but partnerships face no such public disclosure obligations. Special note: there's also a limited liability partnership, LLP, a hybrid between the two. It offers the flexibility of a partnership with the limited liability of a company. It is governed by the Limited Liability Partnerships Act 2000. Which is better? It depends on your goals. Choose a limited company if you want to limit personal risk, need external investment, want to build a scalable business. Choose a partnership if you trust your partners, want simplicity and fewer formalities, are starting small and want flexibility. The key to passing SQE1 is mastering the core legal concepts and becoming familiar with the unique style of SQE MCQs. I published books packed with carefully designed MCQs, each based on variations of legal scenarios to sharpen your analysis and deepen your understanding. It's a must-read for anyone serious about passing SQE1. Scan the QR code or click the link on this YouTube channel to preview the questions. Turn your ambition into qualification. Begin your SQE journey to become an English solicitor.